Good afternoon. Welcome to today's webinar, Testifying at Deposition Trials and Other Settings, an interactive webinar designed to help expert witnesses understand depositions more fully and work more efficiently with attorneys. During today's webinar, our panelists will cover the following: the impact your relationship with the hiring attorney has on your testimony, skills for coping with objections, how to make an impact on your audience when you answer questions, and compensation for your testimony. Our presenters for today's webinar are Craig Heidemann and Nathan Duncan. Heidemann is a shareholder at Douglas, Haun Heidemann, PC. His practice is limited to serious personal injury claims, wrongful death, class actions, civil rights, pharmaceuticals, product liability, and felony and misdemeanor criminal defense. Throughout his practice, he has recovered significant dollar settlements and judgments for his clients. Mr. Duncan is an associate at Douglas, Haun Heidemann. He attended the University of Missouri, Columbia, where he earned his JD in 2007. Nathan is a member of the 30th Judicial Circuit Bar Association and the Missouri Bar. He is also admitted to practice before the U.S. District Court, Western District of Missouri. There will be a presentation of content, followed by a question and answer session, followed by another presentation of content, followed by a question and answer session, followed by a conclusion. If you have questions during the presentation, please use the chat function, which is on the right-hand side of the screen, or the Q&A function, which is found below that. Our panelists have done their best to incorporate the questions that were sent in by attendees prior to the presentation. The panelists will do the best to answer the questions that come up during the presentation during the Q&A session. Approximately an hour after the event, we'll send out an email link to the archive recording and the presentation materials. We do ask that you take time to fill out the survey that will appear on your screen after this webinar is over. I'm now going to turn it over to our distinguished presenters, Craig Heidemann and Nathan Duncan. Craig and Nathan, it's all you.
Hey, thanks, Matt. I appreciate it. Hello to everybody. We've got attendees on from coast to coast today, so it's an honor that you guys decided to invest an hour of your time to hear us, give you some of our observations, tips, and tricks about testifying at depositions, trials, and other adjudicative settings, which might be like an administrative hearing proceeding or some other arbitration or something else like that. Today we're going to try and cover a lot of different topics. First, we'll get into some of the relationship issues that you as experts face with the attorneys that hire you. We'll look at how you can go about preparing so that your testimony is effective, whether it's at a deposition, a trial, or some of those other settings we talked about. A lot of you had questions about what might be discoverable, what another attorney can ask you about yourself leading up to the deposition or in your testimony itself. We'll look at objections that might come up while you're testifying, how you can effectively answer questions that are posed to you, dealing with surprises that might pop up during your testimony. Those never happen. Never, hopefully. And then a lot of you are interested in getting paid for your testimony, which I suspect you're particularly interested in. So that's just an overview of where we're headed today. Well, you know, the relational issues with hiring an attorney, attorneys are special creatures, bless us one and all. We have, when we file a lawsuit, we have various things that we have to prove, some of which require expert testimony, others don't. And the attorney is kind of the ship that's headed to a destination. And we've got a nice little visual there for you, but in many cases, the expert witness is the rudder. You may have a ship that wants to go somewhere, but if it doesn't have the evidentiary rudder that might be provided by an expert witness to get where it needs to go, it's just a ship with no destination. And so the expert witness, whether he's hired to testify about damages or causation or whether somebody breached a duty of care or some other issue involving expert testimony, they are just critical to making a case work. Well, and as we were thinking about this presentation, you know, one of the things we thought about was how important it is when it comes time to actually give your testimony that you have a good relationship, a good rapport with the attorney that hired you, because ultimately
whether it's at trial or possibly at a deposition, that attorney will be asking you questions. Your testimony will be a lot more effective if you've established a good understanding between each other as to how that relationship is going to fit.
And you're going to hear us talk about some benchmarks today. And those are benchmarks at times during your relationship with your hiring attorney where you're going to communicate. Communication is all too frequently, we find, not present in many expert witness attorney relationships. We just don't talk to our experts enough to understand what they need us to do to give them the information to form their opinions, and they don't tell, in our opinion sometimes, they don't tell us enough about how they're going about doing it so that we feel like we're a part of that process.
Well, there's a couple key ways that we thought of that you as experts can develop this relationship and nurture it, I suppose, so that when you're testifying, it really comes through. As Craig talked about, there's benchmarks. The specific times where we think it's easiest for you to talk about the case and to help the attorney understand what your opinions are and how you arrive at those opinions are at the time that you're hired by the lawyer.
Right.
When just before you're preparing your report, if that's, federal court, you will be preparing a report, but if your jurisdiction permits that, that's another great opportunity to talk about those things. And then also immediately before the deposition or the trial. So those are specific times where you have a good opportunity to talk to the lawyer.
It can be as simple as hopefully maybe a little bit more involved in an email, maybe just picking up the telephone, calling them up, saying this is what I'm about to do. Do you have anything that I need to know before I engage on, I've set aside 6 or 8 hours to draft this report. Anything I need to know? Has anything come up in the case? Good time to talk. Makes the attorney feel confident that you and he are headed in the right direction, and that he anticipates that work is going to be done on your behalf, and that he's going to get a bill for that. And that's another issue on communication is attorneys, like anybody, we don't like to be surprised by getting a bill that work has been done by an expert that we didn't know was going to take place.
So, and this is another, obviously money can be a problem when you're in your relationship with your lawyer. So ways to avoid these problems coming up and hindering your, having that good rapport and good relationship with the lawyer are talk, frankly, about money.
Up front at the beginning.
And, it may be a little awkward. We don't like talking about money for some reason, but if you're very upfront and, let the attorney know what your expectations are so the attorney can tell you what that attorney's expectations are. Well, makes things a lot easier.
And, one of the things you're going to hear us talk about later in the presentation today is having a clear fee schedule that you can talk about and explain and stand behind and not apologize for. And so if you feel uncomfortable talking with your hiring attorney about all of the fees that you might charge or your fee structure, think about how it might be when you're asked under cross-examination by somebody else about why you charge what you charge. So writing it down, having a fee agreement, a retainer agreement, that'll just deal with a lot of those issues. For instance, if you charge door-to-door travel time, make sure that you tell your attorney that up front. If you don't provide price estimates, tell them that up front. We like price estimates.
Right, because sometimes your fee agreement will not outline exactly how you're going to charge if you're preparing for a deposition, time for looking over the file or going to a library, something like that. If you call the lawyer ahead of time and say, look, this is what I'm planning on doing, the lawyer can look at his or her budget for the case and decide whether that fits, and you guys can reach some kind of a compromise or something that works.
And it's important for everybody to remember that all cases many times need experts, large and small. So a lot of times attorneys may not have the budget that we might set aside in a massive nationwide mass tort pharmaceutical class action. Sometimes you might have a more simple case where we really only have $3,000 or $4,000 or $5,000 to spend to get us from point A to our conclusion, and so we need to kind of budget that as we go along. All right, well, let's close the door on that, and let's head to preparing to testify. There's a couple of different times that we're going to testify. We might testify in a deposition. We might testify in a trial. We might testify in a deposition in lieu of our in-person trial testimony. So let me just, for those that might be newer to the expert setting, let me just tell you briefly what a discovery deposition is. It's an opportunity where a witness appears, they're sworn in by a court reporter, and they're asked questions by a questioning attorney. That questioning attorney might be an opposing party, or it might be the individual that hired you. You're asked questions, your answers are taken down under oath, and you'll have an opportunity after the deposition's over to review the transcript and make sure that everything that was taken down accurately. That deposition testimony can then be used to support motions that are filed in the case. If you can't or won't or choose not to appear at trial, it can be read to the jury. And so that's kind of what a deposition is.
Now, the big difference between, you see on your screen, we've put a discovery deposition and a deposition in lieu of trial or hearing testimony. The primary difference between those two kinds of depositions, the first is probably going to be more like cross-examination, where the other attorney will have a chance to challenge you on your opinion, certain other things we'll talk about in a minute. Whereas in the deposition in lieu of your trial testimony, you're going to hear from not only the other attorney, but also the attorney that hires you, and they'll record it probably by video, and instead of you appearing live at trial, they'll be using that testimony.
And knowing whether or not it's going to be a trial deposition is important, because if it's going to be videotaped, obviously you want to make sure that you present yourself in dress and in manner as you would as if you were testifying in front of the jury. As you look at the video camera, you will look at the video camera and testify as if it was the jury, making that connection that we like to see our expert witnesses develop with the jury.
And that's a good point, because depending on what kind of deposition, or whether it's a deposition or a trial, and what kind of deposition it will be, it will change how you prepare for those. So we always like to, and I think most attorneys do like to, have a conference with the expert witness before, whether it's by telephone or in person.
We like to do it by telephone because in many jurisdictions, all of our communications with expert witnesses are discoverable, and if we write it down and we, heaven forbid, say something that we might not want repeated later, you've got a document memorializing it. If we discuss it orally, obviously you have to testify what you remember, but we try not to generate a ton of documents in our early relationship with expert witnesses, particularly where they're going to be a witness that's going to actually testify. Consulting experts in many jurisdictions, those communications might be protected from later disclosure. But in that early conference, we're going to identify the goals that the attorney has. Maybe he has a causation issue. Did this negligent act cause these damages? That's what we want the expert to focus on. Or, my client has suffered this damage. How bad is it? Or if you're testifying for the defendant, it might be the plaintiff is claiming this symptom. Is it related to this occupational exposure? So you might testify for the plaintiff. You might testify for the defendant. You just need to know up front what the goals of the attorney, what goals the attorney has in his relationship with you.
Another thing that you want to talk about in these conferences are exactly what your opinion is, and you want to make sure the attorney has a good understanding of that. Especially if if you're ready for trial, if that's what the hearing is going to be, or if it's a deposition in lieu of trial testimony, because you want the attorney, obviously, you want the attorney to have an understanding of what your opinion is going to be, so that the attorney can ask you the right questions, so that you can get your opinion out for the audience.
The other thing that you need to keep in mind in preparing to testify is we all have histories, we all have baggage, we all maybe have a skeleton or two that's come up in our lives that defense attorneys or plaintiff's attorneys are going to do their darndest to try and find and ask you about in deposition. And so if you have had any issues that might come up, tell your hiring attorney about it so that he's not prepared, that he is prepared for it. We had retained a lawyer we had retained an expert at one time that had a Medicare fraud conviction, and he told us about that up front so that we knew going into our relationship with him that was something that we were going to have to be prepared for. Heaven forbid that would have come as a bombshell at trial or in a deposition. We knew about it ahead of time, and we'd found that there'd been some court rulings in the past that had limited the admissibility of that conviction, so we were able to effectively deal with it.
And this is a chance, if you haven't seen it yet, you can see the other experts involved in the case, their opinion in case it conflicts with yours. It's a chance to discuss how you'll address those while you're giving your testimony. I really like to do some practice with the expert, give them a sense of what, especially if it's where they'll be cross-examined, give them a sense of how the other attorney might question them, the types of questions they'll be asked, where they'll be challenged.
Well, let's talk about what types of questions you might be asked at a deposition. Let's see if we can't figure out what we should know to expect.
Well, and these are things that I think, Craig, you agree, that will come up in every testimony that you're going to give, whether it's a trial or deposition.
How long your cross-examining lawyer spends on these is largely a function of their budget. And some experts have asked us, what can the cross-examining attorney asks us? And the answer in many cases is whatever he wants to pay you to tell him, because obviously you're going to bill for your time during that deposition. But they're going to ask you about your qualifications, what schools you went to. Are you board certified? Did you pass your boards on the first try? They're going to ask you whether or not you have any kind of academic credentials or admissions to different hospitals or institutions, or whether you're published, et cetera. They're going to get into your qualifications.
And when you talk about these, you kind of have to walk a fine line. You don't want to come across as real haughty and, I am the world. Maybe you are, but you don't want to come across as too full of yourself. You don't want to be, the world's foremost expert, perhaps, and be to the point that it's annoying. You also don't want to be too humble. I mean, you just want to clearly state, this is what I've done, this is why I'm qualified, so that people that hear that will recognize you as an expert.
And take your time going through this, because many of your qualifications might need to be explained to the jury. They may not understand what board certification is. So you might say, I am board certified, and what that means is I've had to pass additional testing beyond what my state requires, so that our board that accredits us says that I have this advanced level of knowledge about the field that I work in.
On cross, you're likely to be questioned about whether you have any bias or interest towards one type of party or another. If you testify, frequently for plaintiffs, never for defendants, you're probably going to be challenged on that. So you need to be prepared to explain why it is that you testify primarily for one party or the other. It's okay if you do, but you need to be able to clearly state why that is.
You don't need to apologize for it, but you need to be able to explain it. The other things, just in moving on a little quicker, they're going to ask you about what your opinions are. You're going to have your written report, hopefully, before the deposition, so you'll be well prepared to talk about it. Your methodology, that's critical in many cases where we have Daubert issues of reliability and scientific acceptance, or Frye issues, depending on which case your state follows. They're going to ask you what your opinion is about other expert opinions. And they're also going to ask you about any communications with your hiring attorney. So if you've sent letters to your attorney in advance of the deposition or trial, assume that attorney has provided those to the other side, and they're going to ask you about it. So that's why it's always important to keep copies of your correspondence.
Now, one thing that will always come up that may be uncomfortable is the discussion about fees. The other attorney, and frequently your own attorney, will ask you about this. If your own attorney does, it's probably especially a trial or a testimony in lieu of trial, it's a way to kind of diffuse a potential bomb, just get it out there so that the other attorney can't use it as a weapon against you. But the other attorney might ask you what you're charging and why you're charging, how much you've made as an expert witness, in an attempt to discredit you with the jury and make you sound like a hired gun.
But, it's generally accepted that people are worth what they're worth, and if you can explain, you shouldn't charge $5,000 a day unless you can adequately articulate why you're worth $5,000 a day. And if you're worth that, you'll have no trouble articulating why it is that's what you charge. And so I always say it loud, say it proud, but don't charge more than you're worth, and you'll have tremendous credibility.
Well, and if you don't fight the other attorney on it, if you just state that's what it is and that's what I charge and explain it clearly, the other attorney can't do anything with it.
It abuses it. So, as far as preparing for the actual event, we're going to send out to all of our experts, a deposition preparation letter. Now, this link is going to be made available to y'all at the end of the presentation, and it contains 4 or 5 pages?
Yeah, about that.
It's pretty lengthy, and it kind of goes over different scenarios, what we like to see our experts do, things that we'd like to get them to think about. And I always tell them, no matter how they prepare, the last thing they should do before they go to bed the night before giving the deposition is just read over the deposition preparation letter, and they'll have that then foremost in their mind the next day.
Great. All right, let's move on. Several of you submitted questions asking what things would be discoverable that the other attorneys can ask for. And keep in mind, this is going to depend on where you work, what jurisdictions you testify in. So you'll need to consult with the attorney that hires you about specific rules that might apply to you. Generally, though, if you're testifying in federal court, correspondence between you and the attorney that hires you will be discoverable. You're going to have to turn that over.
This concept, and we're going to have another seminar dedicated to report writing, but draft reports where you say, this is my preliminary opinion, attorney, would you like to change anything in it? I am not a favorite. It's not one of my favorite things. It's it's not my opinion to edit reports. That's why I hire an expert. I rely on them to know what their opinions are and not rely on me to suggest to them what their opinions should be. So any of those kinds of letters which contain draft reports, depending on your jurisdiction, will be discoverable.
The other issue that came up in a lot of folks' questions is how far can the attorney really get into my personal information, my Social Security numbers, information about my family members, who I'm married to, do I have kids, where do they live, where do they work, things like that.
We as attorneys don't want your relatives showing up in our jury pool. We'd want to strike them if they were there, and we don't want to rely on you to let us know if that happens. And so we'll ask questions about where you're from, where your family lives. We amended the Federal Rules of Civil Procedure, Rule 5.2, this past year, and so Social Security numbers cannot be filed in any court documents that would be available to the public.
Well, if they are filed, it's limited to the last 4 digits of your Social Security number. There's other things. Your birth date, if for some reason they ask you when you were born, the only thing that can be filed with the court is the actual year you were born. And then the other thing is, if there are any financial account numbers, it's also limited to the last 4 digits.
And keep in mind, the more questions they ask, they're paying for it. So unless they're asking some question that you take particular umbrage with, I would not worry about it. I would hope that the attorney that hired you would adequately protect you from being harassed by the other side and ask irrelevant questions. Let's move on and wonder. Go ahead.
Well, somebody wanted to know, how is it that we come up with this? How do we as attorneys find out personal information about you?
It's everywhere.
It's all over the place, and all we have to do is hit up Google, and we'll find out all sorts of stuff. It may be a good starting place.
MySpace, Facebook, Twitter, blogs. We have access to banks and banks of depositions that have been taken in cases from coast to coast containing some of your testimony from folks that are on this call in other cases. And so if you've offered testimony that a particular methodology is reliable in one case, assume that you would be wary about changing that opinion in another case, because the attorney that's cross-examining you can get a hold of that information and ask you about inconsistencies.
David makes a good point. He says, be careful what you put on your website. Opposing attorney will drill you about statements or claims from it.
Absolutely. And so that's why, the information that we put out there, particularly if you're an expert, your reputation and your credibility and your expertise, that's all that you have to sell. And if you get holes in your reputation or your credibility because of statements you make on Facebook or on your blog or on your website, that can really do harm to your marketability as an expert witness.
And those things are relatively easy to find.
All right. Well, we've reached approximately 20 minutes after the hour, and I think we're going to take some time and answer some questions. Let's see. Give me just one second. We're going to find one right here.
Warren French. We have a lot of client attorneys that ask for drafts. It typically is not for opinions, but for certain words that may have loaded meanings. How should we handle this?
Let's distinguish between the consulting expert and a testifying expert. You need to be aware, as an expert witness, what your role is. If you're a consulting expert, drafts, ideas, you're a partner in working the case up. You are helping an attorney advocate a position within the science.
And you'd be consulting if you're not going to testify later.
Right.
That's the big distinction. If there's no plan for you to testify at trial or render opinions under Rule 26, then you're safe.
You become an advocate, really. In many cases, you're trying to find out a way to help the attorney get from point A to point B within your field of expertise or within the science. And so helping them develop words, that's in quotation marks, that might have a loaded meaning, that's okay. You're just having a conversation about how they might effectively work their case towards trial.
Maybe not necessarily an advocate, but you're instructing the attorney on the science that you're an expert in and how that applies to the case.
But if you, to the contrary, if you are a testifying expert, you really should not be advocating the position of the party that you work for beyond merely taking the facts, applying them to the science, and rendering opinions. That's really going to hurt your credibility.
Before our webinar today, somebody submitted a question about if an attorney just wants you to answer yes or no to the question. There are certain kinds of questions, and we'll get into specifically how to answer questions later, but there are certain questions that are called leading questions, and there are limited circumstances when they're proper. Now, a leading question is a question that suggests what the answer is within the question itself. So I'd say, Craig, isn't it true that John Doe was driving at 17 miles an hour on May 23rd?
Yes.
That's a leading question.
The question suggests the answer.
Those are appropriate on cross-examination, so if the non-hiring lawyer is asking you questions. Now, at least in the Western District of Missouri, there's rules of trial that specifically state that if an attorney asks somebody a question that calls for a yes or no answer, that the witness that's testifying should be allowed to explain why their answer is yes or no.
You can't avoid giving the yes or no answer, but you might say yes, but let me explain. The question may leave out various facts that might make a big difference to conclusions that might be formed by the jury, and so being able to explain your yes or no answer is something that you should always be able to do. Another question is, attorneys ask questions about documents but refuse to let the expert see the document. What should you do? You know, I think it's fair in many cases that if you're asking questions, and it's the rule in some jurisdictions, that if you ask questions about a document that it should be presented to the witness in its entirety, not just an excerpt from it, so that they can look at it and make sure that they understand all that it contains before they answer. And so I think you might say, you know what, I'm not going to be able to answer that until you provide me with the document.
And that's the key. You can qualify your answer. If they're absolutely refusing to let you see the document, say, this is my best answer, but for me to give a totally accurate answer and be sure, I have to see that document. That way, if it comes up down the road, you know, say that happened in a deposition, at trial, if that attorney tries to use your answer against you, your hiring attorney will be able to protect your interests.
Hey, just a follow-up. Jerry Zerg sent us a follow-up question. Can an expert witness be a testifying and consulting expert witness at the same time? You know, somebody out there may tell me I'm wrong, but I don't think you can.
I don't see how that would work, because I think once the intention is for you to testify.
Well, I mean, I think you can be a consulting expert witness, but you have to understand everything that you do in communicating with that attorney is generally going to be discoverable, and it's going to become clear that you're consulting and advocating. I mean, what if an attorney asks you, well, I'll tell you what, didn't this seatbelt fail? And your answer to them is, well, no, the seatbelt did not fail. That is not something that is going to help the attorney's case, and it's going to be completely discoverable if you're going to be a testifying witness.
Michael from Maryland asked if it's advisable to write notes on documents that you review. That can go, understandably, that can be helpful as you're reviewing documents, but, I mean, we just had a case, actually, it's a civil rights case that we're working on. We have an expert witness deposition scheduled for next week. The other attorney wanted a copy of the job file, asked for all our witnesses' notes. It was very simple for our expert witness to say, my job file is very thin, I have no notes.
He didn't even have to go look in his job file to see if he had any notes. He doesn't take notes, and that's because he does this all the time. He writes his report, he makes one draft of it, that's all that he sends out, and there's no ability to pick him apart on the formation of his opinions or the way that his opinion may have changed as he learned different facts. He only has one opinion.
So if you are going to write notes, you need to be aware that there are going to be consequences. The other attorney will look at those and may use those against you at deposition if it changes your opinion.
Cataldo, I think I pronounced that right. A couple of times an attorney hired me, requested me to check and clean my file before deposition. What am I supposed to do in these cases? Well, let me tell you. That is something I would never ask an expert witness to do. In some jurisdictions, I could conceive of instances where that could even be illegal. I mean, we can't destroy evidence, and if you have evidence that's discoverable in the case and a party destroys it or orders it destroyed, that could be a problem.
Don't do it.
Don't do it.
Craig and Nathan, I have a couple questions that have come into me privately. A couple about fee schedules, and I know we're going to dedicate a webinar to that in the future. But what Greg asked, is it appropriate to ask for all documentation relating to the case from the hiring attorney, or is it important to only provide info to the consultant or expert witness on a need-to-know basis?
Well, that may be a function of the budget, I suppose. I mean, obviously for us in our experience, we like to give the expert everything they ask for that they need to render their opinion, because what's going to happen is, when they're being cross-examined, they're going to be asked how they arrived at their opinion.
What did you look at?
What did you look at? And if you don't want it, the expert certainly doesn't want to be put on the spot. Well, the other attorney says, why didn't you look at this? Oh, because my hiring attorney didn't want to give it to me.
Or, conversely, I looked at the secret evaluation that my attorney had done by his consulting expert that says that his case wasn't worth much.
Right.
So all of those things could be discoverable.
But generally you want, I mean, if you as an expert, if it's necessary for you to reach your opinion, then you have to get it from the lawyer.
Here's one last question here. Can an attorney change the status of a consulting expert to a testifying one? Well, yes, they can if the facts were right, but more likely than not, I might change the status of a testifying expert to a consulting one after they rendered an opinion privately to me that I found to be one that would not be one I'd want to offer a trial.
But Emily makes a good point. I mean, it is possible. We frequently, before we even file a lawsuit, we'll hire an expert to look at and evaluate a case for us and maybe render us a preliminary opinion. And it is possible that after we look at the evaluation, file suit, and we decide that person will be our testifying witness.
All right. Well, those are some excellent questions. I hope everybody found our answers useful.
We'll try and cover as many as we can. Obviously, we can't get to all of them, but bear with us. Hopefully we cover it through the rest of the content.
And if we don't get to your questions, send them in, because as we prepare our seminars that we're going to do in the future, we'll try and incorporate some of the questions that you're asking here into our webinars perhaps next month or in months after that. Let's talk about objections, how to handle them. This is one thing that we as attorneys, objections don't bother us. But as we've read your questions and as we've talked to you expert witnesses, we've learned that these objections drive you crazy. You don't understand them, and they break your rhythm, and they really frustrate you. So we want to talk about them.
And keep in mind, there are tons of them. I put a list up. These are just some of the many objections. Some attorneys like to make up their own objections at times, but you don't need to be familiar so much as what they mean as how to deal with them when you hear them.
Nathan, you left one off of there. It's one of my favorites. It's called the speaking objection. It's where and they're not permissible. It's where the attorney says, I object because what Dr. Smith is really saying is that, and then the attorney just rambles on for 3 or 4 more sentences. Objections need to be succinct. They need to be quickly made, and they need to use no more words than are necessary to get the legal point across. So if you hear speaking objections, I'd really raise my eyebrow about the attorney that's making them, because they're generally impermissible.
Now, as you're answering questions, one thing to keep in mind is your hiring attorney, it's possible, will want to make an objection. Or somebody, it's possible, will make an objection after each question that's asked.
That's right. Now, these objections may come up at trial or at deposition. So I want you to imagine as we go through this that maybe you're sitting on the witness seat in front of a jury. Versus sitting in front of a cross-examiner at deposition. Because as you pause, it's going to give your attorney time for his brain to catch up with what you just said. I mean, we're a slow bunch, and sometimes it takes us a minute to process what you said and figure out whether or not, or what the question was, to see whether or not the answer is going to be objectionable. So just pause for a second. The other thing is this. If you're at trial and an attorney makes an objection and you start launching into an answer, I've seen it time and time again, the judge will yell at you. If you want to be yelled at by a judge, or even worse, a federal judge, start giving an answer after an objection's been made, and that tends to embarrass you in front of the jury. It causes you to lose a little bit of respect in their eyes. So take a minute, just a second, before you answer.
One thing to keep in mind is the objections you'll hear at deposition and at trial will be different. You're likely to hear, well, I guess possibly more at trial than you do deposition. Maybe not, because there's considerations about annoying the judge or the jury if an attorney makes too many objections. But generally speaking, at deposition, the only objections that can be raised are those that are to how the question is phrased.
The form of the question, we call it. And at deposition, in 99% of the case, in 99% of the instances, an objection will be made, and then you will give your answer anyway. You will not be prohibited or stopped or hindered in any way from giving your answer. They just need to make the objection on the record, because we as attorneys, if we don't make the objection at the time that the question is asked, to give the asking attorney the opportunity to fix the question, you waive it. And so we make the objections, and then the answer comes out anyway. At trial, the judge is going to say yes or no, you can answer. So that is the main difference in handling objections at a deposition versus trial. Now, in another adjudicative setting, for instance, in arbitration, it's going to be more like trial. The objections are not going to be as many, but you'd wait until your arbitration panel told you whether or not you could answer or not.
Right. I mean, the key thing to remember is deposition, even if there is an objection, unless your attorney says do not answer that question, you're going to have to answer. A judge will later rule on that. But, I mean, the attorney can ask you the same question 15 times. They'll be very repetitive, but you have to answer each time.
All right, and this is the most important one. Don't get flustered. Sometimes attorneys will use objections as a way to break your rhythm. If maybe you're offering trial testimony, your hiring attorney is taking your deposition so that you don't have to travel from New England to Los Angeles to give testimony over a week-long trial. So we're going to preserve it on videotape and show that videotape to the jury. Maybe you're doing a really good job. Maybe you're really explaining yourself very clearly. Maybe you're really hurting the other side's case, and an attorney may start to make objections, valid ones, we'd hope, but objections nonetheless, just to try and break your stride. So don't get flustered. Objections are going to happen. You just let the attorney make them, and then make sure, as you go back to answer the question, that you remember what the question is. And if for some reason the objection is a long one, you can certainly ask them to repeat the question.
Now, there are certain objections that you're more likely to hear than others, just based on the nature of your testimony. The first one is assumes facts, not in evidence. That's where the question includes some certain fact that has not been established by prior testimony.
Or evidence in the case.
Or evidence in the case.
And so if the question assumes, for instance, let's use a stopping distance, a simple stopping distance opinion. If you say, the stopping distance in this particular case was such and such feet, I measured the coefficient of friction, and the street was dry. The objection might be, assumes facts not in evidence. There's no evidence whether it was raining or the street was dry. And then the attorney that was asking you the question would have to go back and show you something or otherwise establish whether the street was wet or dry before you could then offer that opinion.
Now, there are specific objections that pertain to what you might testify to as an expert witness. The first one is about legal conclusions. You as an expert witness cannot testify about a legal conclusion. For example, you can't testify that somebody was criminally negligent.
Sure, you might say the doctor violated the standard of care because he showed up for the surgery intoxicated. And that will help the jury decide whether or not he was criminally negligent, but you can't use the words he was negligent. Ultimately, that's what the lawyer has to prove, but we don't need our expert witnesses to say that.
The other thing is you cannot read reports into evidence. You can base your opinions on other reports. And when I say reports, I'm talking about, if you're looking at another doctor's records,
police report,
something like that on which you based your opinion. You can say, hey, I based my opinion on this report, this report, this report. That's okay. It's when you grab the report, you pick it up, and you start quoting directly from it, you're going to draw an objection every time.
The other thing is the non-responsive question. Now, this is an objection that might be made by the person asking you the question. I might say, doctor, or we keep picking on these doctors. Maybe we should use an engineer. An engineer. Maybe a doctor also. Might say,
doctor, engineer.
We might say, professional engineer. Isn't it true that we did not use enough structural steel on the first floor of this job? And he might say, well, what happened here is we didn't pay enough to buy good steel, etc. And he's really not answering the question that was asked, and we might say, I object. I move to strike his answer as non-responsive. And in that case, the judge later would just say, ladies and gentlemen of the jury, you cannot use anything he said in that last answer to base your decision on. It was not responsive. So we want to make sure that we understand and then answer the question that's presented.
Now, the objection that most people have been interested in and asked us about are these improper hypotheticals. You'll hear this a lot. We as attorneys, for some reason, love the hypothetical question in deposition or even at trial. There's kind of four different, animals here, different kinds of improper hypotheticals. One, where the hypothetical is based on facts that just aren't in the record, that's different than the case at hand. The second one is where the hypothetical doesn't have enough facts for you as an expert witness to render an opinion.
It makes you guess about things.
The third one is where the hypothetical is basically resting on your opinion. It's not based on any kind of fact. And the fourth one is a question that includes argumentative inferences, no facts, where the attorney's basically just trying to pick a fight with you.
It's kind of hard to ask a good hypothetical question that contains all of the facts that you as an expert need to offer an opinion. But here's the way I've had good, very highly respected experts handle this at deposition. They'll say, look, I'm not here to offer new opinions at deposition. I spent a lot of time to form these opinions. I looked at a lot of information, and these are the opinions that I've come up with. If you want to give me more facts and ask me to render a new opinion, I'm going to need to go study on it. Maybe I'm going to need to consult some books. I'm going to need to do this and that. But I just really don't feel comfortable offering these new opinions right here on the spot.
And with that qualification, then you can do it. I mean, these are particularly troublesome. It's a catch-22 for you. If you answer, there's a possibility you're going to harm the case because the hypothetical might be tricky and might have something in it that is particularly damning to your case. But if you don't answer, then you might look like an idiot. The jury's going to say, well, he's supposed to be the expert. How can he not answer the
Exactly.
question?
If we give you new facts and it's something simple, the jury's going, answer it. That's what they're thinking. And the expert's fighting back saying, I can't do that. It doesn't contain sufficient facts. I don't know whether the sky was blue that day. You didn't tell me whether the sky was blue. Well, that's silly. We just need to answer simple questions if possible.
Somebody asked if there's a way to avoid hypothetical questions. The answer is no. And you don't want to avoid them because then you look like, I mean, the jury says he's squirming. He or she is squirming. He doesn't want to answer the question. You need to rely on your attorney, your hiring attorney. If it is actually an improper hypothetical, hopefully they'll object. If it's a deposition, you're going to have to answer the question anyway.
And if there are a lot of hypotheticals and you look over at your hiring attorney and their eyes are closed, you might want to elbow them in the ribs.
Or you ask for a brief break after you answer the question. You say, hey, help me out a little bit.
Here's some strategies to get you through hypothetical questions. You can distinguish the hypothetical that's presented from the facts of the present case. They may be asking you for something that causes you to form an opinion that might favor the other side, but the facts that they're basing it on are completely different from the facts that you're presented with, and so distinguish them.
The other thing to do is to qualify your answer. And Craig kind of talked about this. Say, look, this is my answer, but I really need a few more facts to get to that.
And that gives the attorney the opportunity to completely blow that line of questioning out of the water at trial if you leave some holes there. But ultimately, answer them.
Just answer it.
Don't try and be too evasive because it really damages your credibility with the jury.
That leads to a nice segue, I think, into our next topic, which is answering the questions.
All right, we're right on track. We're here at 20 minutes till, and we are going to move to our next question, which is from, where are we at? This is from Cataldo again. As an expert, am I supposed to consult the literature, books, journals, etc.? One time an attorney that hired me contested the time that I bill for consulting the literature. His point was that if I'm an expert, I don't need to review the literature. That is an excellent question. I mean, we talked earlier about preparing for the deposition. Now, as an attorney, I don't want to bill my clients to have one of my associates educate themselves on something that they probably should already know. Now, there may be new fields that they get into, but I'm not going to charge my clients for that. It's a delicate matter. Many times, I've had experts go to treatises, which I love, because learned treatises are automatically admissible. And so, if you consult with a treatise, bill your time for it, but send an attorney a copy of it so that they can use it.
Well, it would be a good time to let the attorney know in advance that you are going to consult with the treatise, so they don't say, that very problem. I thought you were an expert. Why did you have to look it up?
Yeah, but, a treatise in many cases is a book. It's a text. It's in your office. Maybe you've got it handy. It's not going to take a long time. Here's where it came up for us. We had an expert bill us for driving from Dallas down to Waco to go to a library in Waco at Baylor to look at a book and then drive back. And we really had a problem with that. It's very expensive to take an expert and send them from Dallas to Waco to go to the library. And so if he would have let us know he was doing that ahead of time, we might not have felt so bad about it.
All right. Should we move on to answering the questions?
Yes.
All right. We're going to answer the questions. The number one rule when you do this, you have to remember your audience. You have to figure out whether your audience, if it's a judge-tried case, whether you're speaking to the judge, whether your audience is going to be a jury. So that's the governing principle behind however you're answering questions. As we were thinking about this, we thought about what the ideal, how you should comport yourself ideally, and that is as a professor would. I thought this looked like a very professorial.
She's very professorial.
And we thought about a criminal case we had. We hired a handwriting expert, and he was very effective at, he came across as a professor. Essentially, as expert witnesses, you're teaching the jury or the judge something that is not familiar to lay people.
You want to use the appropriate language for your jury, and that's going to, I often say it's like taking it down to the third grade level. The third grade level is where we're going to speak to the least common denominator, which is whoever would have the hardest time grasping this. We need to break it down so that each and every person can understand it. And that might mean that our answer might be a smidge longer, but ultimately it's going to be simple enough that anybody can understand. Here's an example. There's a procedure called that maybe somebody that was the plaintiff in a case underwent called an endogastroduodenoscopy. Now you might say, and then you might just go on and say the results of the EGD showed that there were ulcerations in the stomach. Well, that might be a painful or uncomfortable procedure. So we might say, well, they had an endogastroduodenoscopy, which is where we take a camera and we put it down somebody's throat after they take this medicine for this amount of time, and they have to go in, and it's an outpatient procedure, and this is how it works. We might break it down so that anybody can understand everything that accompanies that kind of a procedure.
The other thing that is helpful as you're testifying, and this is more appropriate, obviously, for when you're sitting at trial or hearing, and that's to maintain good eye contact with your audience. Now, as the attorney is asking you questions, it's helpful to look at the attorney, but then when you answer, to glance over to the jury box. Now, you don't need to have some psycho zooming in on one specific juror. Don't do that. But if you scan the juror box and teach, think about how your teachers taught you when you were in school.
Eye contact, make sure that you understand that what you're saying is getting through, that they're hearing what you're saying. Now, I always, as an attorney, I'll stand by the jury box so that the gaze of my witness will come towards me and glance along the jury so that they can naturally look back and make that comfortable non-psycho eye contact with the jury. If you're across the courtroom so that you have to turn your head 180 degrees to look at the jury, that's a little more awkward.
And an easy way to think about it is, and the way that I like to do it when I'm presenting to a group or to a jury is, for each thought that I'm making, each point, I talk to one juror.
Right.
I move from one juror, one thought. Another thought, I move to the next juror and kind of scan the group.
That's great to practice that. It's harder to do than you'd think, but it makes your testimony tremendously effective. Good takeaway for today.
You also want to avoid the smarter-than-you attitude, Craig. What's that all about?
Well, these experts are smarter than we are.
Right.
That's why we're hiring them. And they're smarter than the jury because they can only testify if they know things that a layperson doesn't know. But we want to make sure that we present ourselves as an expert in such a way that we really come across like somebody that's not too much different than they are, that we're not going to use words that are too big without explaining them, that we're not going to act like we know more than the attorney that's cross-examining us. You don't want to pick that fight with the attorney that's cross-examining you, even though you might be significantly more intelligent than they are, and they may be asking you completely asinine questions. You want to make sure that you don't fall into the smarter-than-you attitude trap. And it happens all the time. You might say, that'll never happen to me. It happens.
There's some basic things, obviously. You don't want to talk too quickly so that your audience doesn't listen. You also want to keep your answers concise. Jurors have about a 20-minute attention span total. After that, they check out. So your answers you should be able to get your opinion out in 20 minutes or less.
Never lose your temper. Never lose your temper. Never argue with the person asking a question. It happens. But when it does happen, even an unskilled litigator can score points against a well-seasoned expert if that expert loses his temper.
Because it destroys your credibility with the judge and the jury.
It becomes personal, and we don't want to make it personal. Do we need to take a few more questions?
No, we're going to do it right before our wrap-up. We have a few more seconds.
Super duper.
All right, so attorneys, we don't always ask the best questions. We're not perfect. Sometimes the questions can be vague or ambiguous, where the question itself is just impossible to understand.
And if that's the case, just say, I don't understand. You're going to have to ask it a different way.
The other thing is sometimes we like attorneys, we like to sound smarter than we are. We would like to think we understand your opinions. If we don't, and we try and say that in the question itself, it's okay to correct the attorney. I would expect that if I was asking my expert witness something about their opinion and I misstated science, I would need you to correct me so that the jury has a clear understanding of what the science is behind your opinion.
And what happens more often than not is you're going to find that attorneys might mischaracterize your prior testimony. So you'll testify about opinion A, and you'll say, okay, doctor, you've just said opinion B. Now tell me about this. And you'll know that what he just said was not at all what you testified to earlier, and so you'll want to make sure that you might say that mischaracterizes your earlier testimony. Now,
they don't do that on accident. That's a little Jedi mind trick. You try and slip in, something that will come back to harm the expert.
Now, hopefully the attorney that's presenting you is going to catch that and is going to make that objection. But if for some reason he doesn't, make sure that you point out that the question mischaracterizes your earlier testimony.
All right. Surprises.
Never happen, do they?
Never. I hate surprises. I found this freaky. This is what I thought of when I thought of surprises. This Jack in the Box, and this is the scariest Jack in the Box I've ever seen. And, these surprises that we get at deposition or even worse, trial, are terrifying. The first kind are these where you discover while you're giving your testimony that you have not been given all the information that is actually out there.
Now, that can happen a couple of different ways. The attorney that hired you may be lazy. They may not have thought to send you copies of the interrogatory answers. They may not have sent you your party's deposition. They may not have sent you all of this other discovery that's taken place over years in this case, and they've only asked you to combine your opinion to one area when you as an expert need to understand that you should be asking for all of the interrogatories, all of the requests for production, and all of the other depositions so that you can be familiar with them and you won't get torpedoed at trial by information that was out there that you didn't get. Now, they may not want to pay you to do that, and if so, that's okay. But you can have your checklist and say, look, I asked for it. They decided not to give it to me. I mean, if they decide they want to drive a Ford Taurus instead of a Cadillac, that's certainly up to them, but you're prepared to be a Cadillac.
Well, and that goes back to what we started with, the relationship. Up front, you need to explain to the hiring attorney what you expect. You expect you'll be provided those interrogatories and requests for production, things like that. Because ultimately, when we go back and look at deposition banks or trial testimony transcripts or talk to other lawyers and they say, oh, it looks like this expert fell on his face during deposition, the deposition transcript may not show that the attorney didn't give you something. So as you're trying to market yourself and build your credibility with attorneys and the audience, you need to make sure that you've equipped yourself by asking the attorney for the stuff you need.
Here's another thing. If in your past dealings as an expert you've had some unsuccessful run-ins with Daubert motions in federal court where the other side has challenged your methodology or the reliability of how you reached your opinions and you've lost, tell your hiring attorney about it because they may or may not search all of the jurisdictions in the United States for published and unpublished Daubert rulings on you. But you certainly would be aware whether or not your testimony has been booted in other cases. And if your testimony has been excluded in other cases, you've got to tell the attorneys that hire you about that because if it comes up at deposition, they're going to look at you with fire in their eyes.
Well, and that kind of goes to the next area where you might be surprised is the impeachment. Hopefully you're not. You may be surprised to find out that the non-hiring lawyers discovered that DUI that you got 8 years ago that you didn't tell anybody about before the deposition.
And if you don't want to talk about things that have happened in your past where you've had criminal issues, if any, hopefully that don't relate to your profession, don't put yourself out as an expert witness.
You're going to have to talk about some uncomfortable things. It's just the nature of the beast. So the best way to deal with these are to be totally honest up front with the hiring attorney so that they know about these skeletons in your closet and can deal with them appropriately. If for some reason you haven't been totally honest and they do come up at deposition, be honest. You're under oath, so you should be anyway, but don't try and wiggle out of something bad if you know it's true. Tell the truth and deal with it.
All right, let's move on to our last topic, I think.
Yes.
Fees. Now, we will do a much more in-depth study of fees, getting paid on time, getting paid a fair rate, marketing yourself, etc., during another webinar, and I'd encourage you all to tune in for that. I think it's going to contain a wealth of information that's going to help you be much more successful as an expert in your particular field. Ultimately, we want to get paid for offering our testimony.
The federal rules, in fact, Craig, provide for, it's Rule 26B4C, that the court can in fact, it says the court must require that the party seeking discovery pay the expert a reasonable fee for time spent in responding to discovery. And this would include giving your testimony at deposition.
Now, deciding what to charge for your fee and how much to charge, ultimately, courts are not going to interfere with that. So if you charge a reasonable fee, you're not going to have anybody looking over your shoulder telling you that you're charging too much or too little, with the exception of, and I'm skipping ahead just a smidge, with the exception of the unreasonable fee. And Nathan, what happens in situations where an expert says, I'll only give my deposition if you pay me $10,000?
Courts and other parties will use that rule that I cited earlier against you and say that your fee is unreasonable. There was an article recently where
well, that's just last week.
An expert, a neurosurgeon wanted to charge $7,000 for a two-hour deposition, $5,000 for the first hour, $2,000 for the second hour. The judge said that's way out of control. There's no way you can pay that. He looked at some other cases. I mean, it wasn't the only one, from some other districts, and found that it was just grossly excessive. So.
You can charge a reasonable fee. You can charge your travel time. You can ask for prepayment of all or part of your fee. But keep in mind, the touchstone is that it has to be reasonable. And you may not have a problem explaining your fee to the people that want to take your deposition, but if you're an expert, you may have to stand in front of a judge someday and explain why your fee is reasonable. Don't make any apologies about it. Just be able to adequately explain why you charge what you charge and know what other experts in your field are also charging, where they have similar qualifications as you might.
That brings us to our last Q&A session. Somebody asked a question actually about fees, whether you should just, as soon as you explain, say what you've been paid, explain why you're worth it. They thought maybe it looks like you're being too defensive. That's probably a good point. I mean, it's all about how you explain it. Perhaps it's better if your other attorney, if your hiring attorney cleans it up a little bit, if the non-hiring attorney has asked you, what have you been paid, and leaves it at that.
Well, it's not an embarrassing question. Don't ever answer the question that's not asked. If somebody's not asking you why you charge that much, I probably wouldn't launch into a monologue about how much you'd make if you were back working at your office that day seeing patients. It's none of their business. But you might say, look, other experts in this field charge a similar amount based on the qualifications that I have, and I've researched it. I've consulted with TASA, and they've told me this is a reasonable fee, or you can look in this directory, and we can find out, what other folks are charging. And so as long as you're within the geographical fee structure of the other experts in your area, I think you're in good shape.
Emily asked what the best way is to deal with a mediocre or bad expert on the other side if they've rendered an opinion that is just out there. Obviously, you don't want to get into personal attacks on that or challenging their qualifications, but ideally, the science is going to back you up, and you'll be able to point to perhaps their methodology, how that other expert arrived at their opinion, and that's the way that you can poke holes in it that way. Somebody asked if while you're being, while you're giving your testimony, if you can have the transcript reread to you.
Nathan, you can, and court reporters anymore, they can do it more easily than ever. They hook up their stenograph machines to their computers, and it will translate the words as they're coming out in many cases, and it's okay if you want to have it read back. But I would not do that unless you really want to know what you just said. It's more easy to say, could you repeat the question?
Joseph Minton asked, how do you handle the question, are there texts which you consider authoritative on the subject? Yes, absolutely, if there are.
Well, sure. I've had experts refuse to admit that Cecil's is not an authoritative text in the area of medicine. It is, and if there are authoritative texts, you better know what they are. Make sure you look at your bookshelf before you go out to testify and see which books you in fact have.
Greg asked, how do we know what documents or depositions are out there for you to use while you're forming your opinions? Typically, this is what you're looking for: interrogatories, requests for production, requests for admissions, and depositions. Maybe some things that have been subpoenaed, but it's a very limited universe. And you can pick up your phone, call your hiring attorney, and say, I need, what discovery have you done?
Right. Understanding that discovery is tripartite. It includes these interrogatories.
Tripartite.
That's a good word, isn't it? It includes the interrogatories, the request for production, and these requests for admission. And if you ask for them, the attorney might be very surprised that you're knowledgeable about the litigation process and might say, I didn't think to send those to you, but now that you mention it, I'm going to send those over for you to read. They might take, I can't imagine it taking more than, 20, 30 minutes to read an average set of interrogatories and to, document review. That comes in all shapes and sizes, but obviously we're not going to send you every document that's been produced in a case. We might only send the medical records or the design reports or things like that.
Cataldo Doria asks what's considered a safe haven for an expert in percentage of total income. I assume that's about, what you're charging. And really that'll depend on what other experts are. I don't know that there's a specific percentage that's out there.
There are full-time experts, and I think if you ask that person what a safe percentage would be, they'd say 110%.
Charles wants to know what a reasonable time is to wait for payment after you testify. I don't know that there is a reason. The best way to handle that, I think, is up front in your either do prepayment or in your retention agreement say I expect payment within 2 weeks, whatever it is that you want it in.
When we talk about fees, we're going to kind of talk about this new thing that we are huge fans of called the flat fee or segmented flat fee arrangement with our expert witnesses, and more on that later. But that deals with that problem once and for all.
We had a couple people ask if you've stipulated before the deposition that you demanded prepayment before the deposition and you don't get prepayment, do you have to participate in the deposition?
Depends.
If you've been subpoenaed, I think you probably should sit there and be questioned. But if it's a
in many cases where there's been an issue on that, we've just told opposing counsel we're not producing our expert because our expert says you haven't paid them. We've had other attorneys, they bring money to the deposition, and you've got this weird exchange of money between the interrogating attorney and our expert right there on the record, which is kind of unusual. Well, I hope we've answered all of your questions. We're concluding right on time at 3 o'clock Central Time or 4 o'clock Eastern Time. We've really appreciated this opportunity to visit with you. We hope that you found the information useful, and we look forward to our next webinar, which I think we're heading to the fee issue probably for the next webinar.
And we'll probably do it next month. These are some of the major things to take away, and then on the bottom there you'll notice there's a link. That's the URL for that deposition preparation letter Craig talked about earlier. So thanks for being here, and we appreciate your attendance and your questions.
Look forward to next time. Thanks.
Craig and Nathan, thank you very much. I hope all of our attendees found the presentation as insightful as I did. You guys did a great job, and I thank you for that. The next webinar in this series is going to concentrate on fees. As Craig and Nathan said, it was what many of the questions were centered around. Please take time to fill out the survey after the event. We appreciate all the feedback that you can give us. I will be sending out a link to the archived recording of this event, hopefully by the close of business today. If not, it will be tomorrow morning. I will be sending around this deposition preparation letter, as well as the article that Nathan referenced in the presentation about expert fees. We'll probably be sending around the PowerPoint presentation as well. Please look for an email from me shortly. In the meantime, please look for an email from the TASA Group in your inbox in the next couple of weeks or so announcing the second part of this series. Thank you to everybody for taking the time to come out today, and thank you, Craig and Nathan.